Good morning. Welcome to Tuesday, day 2 of TPI's Virtual Aspen Forum 2020. I'm Scott Walston, President and Senior Fellow at the Technology Policy Institute. Yesterday, we covered topics in privacy, and today we're covering competition and antitrust. Very timely. Competition and antitrust have always been exciting, but of late have become very hot topics. Just take a look at the House antitrust hearing a few weeks ago, and of course, earlier today when the Department of Justice filed its complaint against Google. Debates focus not just on investigations and enforcement activities, but even on the most fundamental question of whether antitrust policy should focus on consumer welfare, the way it is in the US, or on competitors, a historically more European approach. We've got 2 great panels today on competition and antitrust. The first is a panel of current and former FTC commissioners. Politico reporter Leah Nyland was scheduled to moderate, but DOJ had the temerity to release its complaint this morning, pulling her away. We're honored, however, to have her colleague, Stephen Overley, who is also from Politico, take over moderating duties. The second panel today will focus on competition in the attention economy. For lunch and downtimes, we hope you'll join us in GatherTown, the interactive 2D St. Regis and Aspen we've built. If you don't have your instructions on how to get there, reach out to Jane Creel. Now we'll move on to our first panel. Stephen, the floor is yours.
Good morning, and welcome to the TPI Aspen Forum and today's panel, the FTC and the Next Administration. I'm Politico reporter Stephen Overley, filling in today for my colleague Leah Nyland. Throughout our discussion today, we'll be taking audience questions using Slido. Aspen Forum alumni will be familiar, but if you're new to the conference, if you'd like to ask a question, you can either download the Slido app on your phone or open a web browser and go to www.sli.do. Type TPI Aspen 2020 into the event code field, and then you can send us your question. We have a great panel this morning with 2 former and 2 current commissioners from the Federal Trade Commission. Edith Ramirez is a partner at Hogan Lovells in the Antitrust and Cybersecurity practices. She served at the FTC beginning in 2010 and was chairwoman from 2013 until she stepped down in 2017. Josh Wright is the executive director at the Global Antitrust Institute at George Mason University. He served as commissioner from 2013 to 2015. Commissioner Rebecca Kelly Slaughter joined the FTC in May 2018 for a term that lasts until September 2022. Before joining the FTC, she was the chief counsel to Senator Chuck Schumer of New York. And lastly, Commissioner Christine Wilson joined the FTC in September 2018 for a term that lasts until September 2025. Before joining the FTC, she was Senior Vice President for Legal, Regulatory, and International at Delta Airlines. She also previously served as Chief of Staff for FTC Chairman Tim Murris during the George W. Bush administration. Thank all of you for joining us today. I want to start with the big news of the day. The Justice Department and a number of Republican state attorneys general have filed an antitrust lawsuit against Google, marking the largest antitrust case to be brought against a tech giant in decades. How significant is this case, and what does it tell us about this administration's approach to market power in Silicon Valley? Commissioner Wilson, if you'd like to start things off.
Well, thank you very much. Good morning. It's good to be here. I am going to punt this question to one of the non-sitting commissioners, unless Becca would like to take it. But given that it's ongoing litigation and that obviously I haven't had a chance to review the complaint and that it's a sister agency, I will. I'll defer to others for their observations.
Commissioner Slaughter, I trust you will want to punt on that one as well.
Yeah, I agree with Christine. I think this is better answered by people not currently sitting in government.
Well, Josh, let's come to you then. What do you take to be kind of the significance of this lawsuit?
Well, first, let me say it's a pleasure to be here, and it is wonderful to sit on a panel like this with these great sitting and former commissioners, and long time no see in person, but this will have to do, and I will do my best to answer the question with the caveat that I got to about page 5 of the complaint before we started, which got me just about to the end of the caption. So I do know who is suing who, but that's about it. But look, I think in terms of the significance, think for the same reason you've got two competition panels today, and we've got a House report and a lawsuit. I think it is fairly clear that in the ebb and flow of antitrust moments in history, it always tricks me whether ebb or flow is the high one, but we're at the high one of those two. And I think it is one of the more interesting times to be thinking about antitrust issues. In terms of the complaint itself, I think we'll have to see. I don't think it's any secret that there are investigations around state and federal governments for Google and other large tech companies. And look, we've got a system in place and laws in place and Article 3 judges out there to adjudicate those disputes, and we will see what happens. But I think no doubt that the complaint is part of a bigger, important movement and about what to do about antitrust and whether the current institutions are up to the task. And pretty hard to answer if they're up to the task and how they're performing until we sort of see how those disputes play out in federal court. But an interesting time to be sure.
Well, Edith, would you like to weigh in on that question as well?
Stephen, frankly, I didn't even get to page 1. I haven't downloaded the complaint, so I can't even speak to that. But I certainly echo, Josh's comment, which is that it's a very significant moment and has been for the last recent years for antitrust. And I think the fact that a full day is being dedicated to the issues that Commissioners Wilson and Slaughter are dealing with in their day-to-day roles really does speak to that. So, and let me just also add that I'm really delighted to be on the panel and having an opportunity to have a discussion about these important issues with my fellow panelists.
Excellent. Well, we are talking today about antitrust in the next administration, which could be led by a President Biden, depending on how Election Day shakes out. Edith, I'd actually like to come back to you. How do you think a Biden administration would handle antitrust differently?
Stephen, I think that's the million-dollar question. And certainly a key among that is going to be, who would be heading up the two agencies, the FTC and the Department of Justice. I think we are at a time, given the significant concerns that have been raised with regard to the state of antitrust. I'll note that I don't agree with all of those criticisms, but I do think it is important for us to take a hard look at how antitrust is working. But you see some very significant divides in views about the way antitrust ought to be applied when it comes to the digital economy. You see that certainly even within the FTC, within the commission, and you have different views amongst the commissioners on our panel. So I think it remains to be seen how that is all going to play out. But I do consider this to be if Vice President Biden were to win, I think it will be a momentous time for antitrust. And frankly, we don't quite know how it'll play out, but I'll leave it there to start.
Well, Josh, do you have a theory on this? I know a lot of this does depend on who's running the various agencies, but there's some tension right now, I think, among Democrats about how to approach antitrust moving forward. I wonder how you see that playing out if we do have a change in administration.
It's like Edith said, that is the million-dollar question. I don't think I've got a million-dollar answer, but I think there's sort of two things in that as that tension plays out, and I think you've got a couple of different visions within the Democratic Party on how to do antitrust, and are not totally in tension with one another, but two different versions. And you've got a similar dispute on the right as well, with sort of competing visions for how to think about the role of antitrust. And I think there are two things to watch, and one, of course, is personnel decisions, and I'll defer to others on the tea leaf reading on who would get what gig and how. But the personnel decisions are important, but I think equally important are approaches to antitrust. Look, some of the criticism that's been levied about past administrations, Republican and Democrat, have been about willingness to bring cases. My own view of that, you take merger policy, for example, the agencies win a lot more cases than they lose. I think the agencies have lost something like 3 litigated merger challenges in the last decade. And, you know, people like me point to that data and say, look, if you're talking about merger law being broken, I don't know what kind of win rate you want. And people who are critics of antitrust enforcement being insufficiently vigorous say, well, goodness, with that win rate, we ought to bring a heck of a lot more cases and you know, be out in federal court more, maybe dust off other tools like Commissioner Chopra has had discussed rulemaking quite a bit, and sort of on the competition side, sort of doing more rulemaking. So I think the dimensions of the data of the debate, to me, are really sort of on 2 fronts. And one is, I mean, there's a lot of fun to be had talking about you know, personnel, but I think also just sort of how one envisions the tools available to the agencies, how much litigation should be happening, whether the agencies are going to get out in part of the battles there'll be a bunch of reform proposals that come out of the House report or other places, whether the agencies are going to play a role in supporting any of that. I think those are sort of big questions. I could imagine a Biden administration antitrust enforcement institution that looked at a lot of the House report proposals and said, I'm not interested in overturning Twombly or Brook Group or Trinco. And I can imagine one that did, but I think that's sort of an example of the sort of clear divide between the 2 potential paths.
Well, I do want to come to the House Judiciary report shortly, but before we do, Commissioner Slaughter, I'd be curious to get your take. What do you think would be different at the FTC if you and your Democratic colleagues had the majority?
Thanks, Stephen. And I want to echo my colleagues. Thanks for having me here and preempt my comments with 2 caveats. The first is that I am in peak 2020 in my household right now with no actual wired internet going into my house. So I have hooked up various hotspots for myself and my 2 elementary school learners who are working downstairs. And I have my fingers crossed that they stay hooked up and that my baby stays asleep and we can have a conversation. But if I disappear, it's not because any of you offended me. It is because my connection has betrayed me. So that's the first caveat. And the second caveat is, as Christine and I are supposed to say before we say anything, that we are here speaking for ourselves individually and not for the commission as a whole, or other commissioners, as probably will become very clear as we both speak. So the first thing that I wanted to say in response to your question is, I'm not actually sure I agree with Edith and Josh about the depth of tension in the Democratic Party about how to approach antitrust. I think there's a lot more agreement than disagreement about it. And that's a change over time. I think that there is some broad consensus among Democrats that we need to be, as Josh said, dusting off new tools, brushing up our enforcement, being more aggressive, and some broad concern about concentration in the economy, and not just in questions of big tech, really across the economy. You know, the fact that the Senate Democrats' first piece of economic agenda after the 2016 election was an antitrust piece on the better deal says a lot. And I have some personal experience with just how much consensus went behind putting that document out. So I think that there's a lot there. I don't have any inside information about how a President Biden would particularly approach these things, but I do know that among the breadth of the Democratic Party, there's a lot of common ground about how we should be doing things. So that is the first thing I was going to say. And then within the FTC, I think, you know, both Commissioner Chopra and I have talked a lot about how a lot of the tools we have are limited, whether they're limited by what we think of as challenging or bad jurisprudence, or whether they're limited by actually not sort of statutory limitations or resource limitations. Those limitations are real. I think we still think we need to do everything we can with the tools that we have and demonstrate that we're really trying in order to make a case for how those tools should be changed or could be changed if Congress thinks that that's appropriate. And I take Josh's point about the win rate, but I would look at it a little bit differently and not just say, well, that shows we should bring more cases, but to me, it also reflects a selection bias about which cases we choose to bring. And, you know, when we have limited resources, do we only choose to litigate cases that we are more certain to win, not just the universe of cases where we think we are right? I think there's a lot of factors that can go into that top line statistic. So all of that is to say, I know, at least from my colleague, Commissioner Chopra and I think we think a lot about what tools we have at our disposal and how we think about case selection and case prioritization and how we think about resolving cases that we have out there in order to make our agency as effective as possible with the limited tools and resources that we have now.
Commissioner Wilson, I'd like to hear from you too, kind of on this question. If we do see a change in administration and a change in control at the FTC, what do you see being kind of the big changes to your agency?
So obviously, thank you to Commissioner Slaughter for giving the disclaimer for me before I launch into any substantive remarks. And I will note, Becca and I agree a great deal on some issues like consumer privacy, data security, and then not so much on antitrust, and you're going to hear some of those differences today. In terms of what a Democrat administration would bring in terms of antitrust enforcement, I think the dissents that Commissioner Slaughter and Commissioner Chopra have written provide good guideposts for what we might see. I think there would probably be more intervention on vertical mergers. I think you would see a greater call for holding CEOs individually liable for conduct, regardless of whether they had knowledge of it or whether they participated in it. I think you would see far greater horizontal merger enforcement. I think that that you would see more unilateral conduct enforcement. And one of the interesting things that the Commission has grappled with in recent years is the issue of finite resources. And so even though there are lots of ideas about what the Commission could be doing, setting aside whether it should be doing those things, we live in a world of finite resources, and the FTC's budget, as a matter of fact, has been shrinking essentially instead of growing because we have to pay more in terms of compensation and benefits to our staff each year. And so the amount that we have left over for law enforcement activities is shrinking. But the ideas about what we should pursue in terms of enforcement and investigation are essentially endless. And I do always find it ironic when members of Congress come to us with essentially an endless list of the things that we should be investigating and prosecuting, but do not give us any more money despite the fact that the economy is growing significantly. And so I think if the Democrats take over again, it will be an interesting revelation in terms of the types of conduct and prosecutorial discretion, they exercise and go after, because we do live in a world of finite resources and there are only so many things that we can do. And so I think, who knows what would happen if the agency were given significantly more funding. Again, I think my Democrat colleagues' dissents give a good guidepost of the kinds of things in which they would be interested. So too does the House report, and we'll probably get into discussing that in a bit. But absent further resources, it's hard to imagine, frankly, that the Federal Trade Commission could be doing more, because we have an amazing staff who works incredibly hard and pursues every avenue available to them to enforce, given the resources that we have.
Well, I do want to move on to that House Judiciary report you just mentioned, in part because it could in some ways serve as a blueprint if we do see a change in administration for how there could be some new thinking on antitrust. As folks I'm sure are familiar, the House Judiciary Antitrust Subcommittee just finished a 16-month investigation into antitrust and the major tech platforms. One of the findings, the panel found that Apple, Google, Amazon, and Facebook have acquired more than 500 companies over the past 12 years, and that the antitrust agencies did not block any of those deals. The report said that the DOJ and the FTC have, quote, consistently underestimated by a significant margin the degree to which an acquisition would undermine competition and impede entry. So I'd like to start with the former commissioners, if I could. What are your reactions to kind of those findings? And looking back, is there anything you would have done differently in your time at the commission?
Stephen, I'm happy to lead off on that question. Let me say that first of all, that I take issue with a significant premise of the report, which is that there's an institutional failure at the two agencies to effectively enforce the merger laws. Let me also say that certainly during my tenure and in my experience, the agency never hesitated to bring a case where it felt that the antitrust laws were being violated. Clearly, resources have a huge impact, and that's very, very significant. But to me, the idea that the agency, certainly, again, in my experience at the FTC, if we felt that there was a violation of the laws, we were going to be bringing a lawsuit. At the same time, when it comes to merger enforcement, that exercise is by its very nature forward-looking. And when you're looking in particular at the area where there's a lot of concern and criticism, which is in the area of nascent competitors or potential competition, in that arena, it can become very difficult for agencies to make predictions, and perhaps one can be, the agencies can be accused, that may be too strong a word, of worrying perhaps too much about getting it wrong. I do think that I don't believe there's any systemic failure when it comes to merger policy. I do, however, think that because by its very nature, trying to make predictions can be very challenging, the agencies don't always get it right. And I really credit the FTC for having embarked on the 6B study to look at this issue and to look at it more broadly to see if they find reason to take a very different approach when it comes to, or incrementally different approach when it comes to merger policy. So in my view, there has not been a systemic failure, but there are certain areas that I think do warrant looking at, and I'm pleased to see that the FTC using its authority to conduct studies to do that. And I think the one area that I'll mention where I do think it is challenging for agencies is in the area of potential competition. When Josh and I were on the commission, we brought a case, the Steris Synergy, seeking to block the Steris Synergy merger, and the court disagreed with us. And those cases are challenging to bring. We would have brought that case regardless, of the outcome, but it does highlight that one has to be conscious of the limitations that are placed by the courts and by relevant and applicable law.
And Josh, what's your take here? Is there a systemic issue, within these agencies? And looking back at your time at the commission, should things have been done differently?
So let me agree with Edith, I think wholeheartedly. The idea that there is a systematic bias against bringing those cases, I think is one, false, and two, not borne out by the data in the report. I mean, the data, the report points to a lot of mergers that happen. The report doesn't make any claim that they've identified sort of systematically anti-competitive transactions that went through agency review, nor does it try to do that. I think this is an area sort of dealing with the famous Yogi Berra quote, prediction is hard, especially when it's about the future. And these are the most forward-looking of antitrust cases, talking about nascent competition and trying to predict effects. an example that comes to mind about the FTC's willingness. And the one way to predict outcomes in these cases is to ask me my view and bet the other direction. I mean, the two big potential competition cases at the FTC when I was there were Stare Synergy, where I voted to bring the challenge and we lost. But I think a case that shows the FTC's willingness in this area is actually one where I dissented, which was Nielsen Arbitron. My dissent was on the grounds that the product at issue and the market at issue and the complaint didn't exist yet by any stretch of the imagination. And my dissent was we were out here on a really adventurous complaint alleging competitive harm in a market that did not exist, in my view, would never exist. I was outvoted, but I think to the credit of the agency and the majority, wasn't a second thought about bringing that case because they believed that there would be harm, and we disagreed on the facts, which is fine. But many disagreements with the majority in the commission while I was there, but their willingness and dedication to bring cases when they thought the law was violated it's not one of those. I think the agency, when and where they felt like there was anti-competitive conduct, including in nation competition cases, was certainly willing to bring them. This is an area that is difficult. I think it's an area where we need more information to know. It's an area where we don't know yet what we don't know. We don't know if there are anti-competitive transactions out there that we're missing. I want us to know that so we can go bring the cases. I'm sure everybody here who ever had a vote or does have a vote wants to know that. And so the 6B study is a great idea. Academics are paying attention in this area and starting to study it more closely. And I think as much as, study and get more information is often dismissed as a prescription to do nothing. Goodness, having information is a really important thing to getting these decisions right and making sure that we're doing more good than harm. And so I think the agency now taking seriously that issue and going out and collecting information is the responsible thing to do, and I think can inform decision making in those areas, and I look forward to the results.
Well, Edith, I want to ask you, you were at the FTC when it did its initial investigation into Google search, and you all closed that probe in 2013. Obviously, search is now getting new attention with the DOJ complaint. Do you think, looking back, that was the right decision on Google?
Stephen, I do. I think let me say that the majority decision in connection with that investigation was consistent also with the recommendation that was made by staff. Was it a close call? Absolutely. But ultimately, we felt that we weighed the evidence appropriately and that we reached the right outcome. Now, again, we're working with the facts that we had at the time. And it may, antitrust is very, fact specific. And I do think, again, that generally speaking, I understand, and it's certainly appropriate for stakeholders and the public to raise questions about whether or not the agencies have been as active as necessary. And I think those are good questions to be asking. And I'm certainly looking with interest to see, the results of other matters that are pending before both agencies. But again, we do the best that we can with the facts that we have at hand, and I don't regret that vote.
Well, back to the House Judiciary Report, and I'd like to come to the two sitting commissioners on this question. But the report included a long list of suggestions and recommendations for changes to antitrust law. What do you think of some of the broader proposals, including the idea of creating a sort of Glass-Steagall for the internet? Commissioner Slaughter, would you like to start, or Commissioner Wilson?
I'm happy to start.
I'm happy to go ahead.
Okay, thanks. First of all, I thought the report was an amazing undertaking. I mean, I worked in Congress for a decade, putting together the set of hearings, the type of investigation, the document collection, the depth of the work that committee did is truly mind-boggling to me. And I really admire and am in awe of the work all of them did on that. And I think a lot of their suggestions are really good. I mean, I think they raise some very serious, very important questions about the way our digital economy is operating. I am trying to be mindful of what is within the bounds of current law as I think about our job today and what we have in front of us. And a lot of their suggestions were about changes in the law that I think merit serious debate and discussion, and I'd like to see that moving forward. I listened, Josh, to the podcast you did last week talking about the report, and one of the I don't want to put words in your mouth, but one of the conclusions I heard you draw is that legislating is hard and passing legislation is challenging. And so it's difficult to anticipate how much or of these suggestions will move forward and to what degree. And I think that that's absolutely right. One of the other things I learned from working in Congress is that even the best, most consensus-driven piece of legislation has a marginal chance of passing. And it is certainly true that there is not universal consensus around the suggestions in the House report, but there is a really important debate that's happening. And I think that that is good. And I think it's good for antitrust law to ask these hard questions. It's good for the views to be aired. I like to see some of these proposals move forward. I know not everybody feels that way, but I think it's really valuable. And particularly the ones that undo what I think are some of the more damaging court decisions that make enforcement of the laws as they were written and as they were intended difficult. But in the meantime, where I really am focused is what can we do at the agency, even anticipating no changes in the law whatsoever? What are the tools that we have and how can we help think about it? Because I think the points that Edith made and Josh made about predictions being challenging and us having an obligation to go back and look at what kind of predictions did we make in the past? How can we refine our predictions and do that better going forward is really important.
So I would make a couple of preliminary points. First, with respect to resources, let me just clarify what I meant. I believe that the Commission brings all of the cases that it should bring, given the law as it currently stands with respect to violations and what constitutes a violation. My point is that if we significantly expand the spectrum of activities that we define now as unlawful, then we are going to have significant resource constraints. We're already constrained, but I do believe we're bringing the cases that we should be doing. But if we're going to significantly expand and bring many, many more cases, because we're now going to define many, many more things as unlawful, the Commission's resources will need to expand significantly. And second, when I think about the proposals that are being made, whether coming out of the House or whether from think tanks or from practitioners, I always go back to the question of how we want to structure our economy. Honestly, I think the overarching question that we should be asking ourselves is what kind of incentives do we want to create? Do we want to encourage creativity, innovation, entrepreneurialism, and investment, or do we want to incentivize free riding, rent seeking, and regulatory gamesmanship? And I think free markets with light touch regulations when you've got market failures do incentivize innovation and entrepreneurialism, and that's what makes America great. And I think that when you have heavy regulation, it stifles innovation and it raises costs for consumers. I think with respect to the so-called Glass-Steagall for businesses, I think it's very interesting that the report cites the railroad industry as an example of where regulation took place. It's held up as a model. And there was the Hepburn Act that said railroads can't vertically integrate. And there were far more regulations that were in place, both for railroads and for airlines. And what the report doesn't mention, which is fascinating to me, is that there was a bipartisan consensus that emerged in late 70s, early 80s, that regulation actually stifles innovation and increases costs for businesses, which of course increase prices for consumers. And there are there are tons and tons of articles out there that explain this phenomenon with respect to railroads, with respect to airlines, with respect to other regulated industries. And nowhere in the report, as it holds up the railroad regulations as a beneficial framework, does it mention actually Congress repealed that because it turned out to be so harmful. So I think we should not be in the business of determining what lines of business a company can pursue. I don't want to be in the business of telling companies you can be in these lines of business and not be in those lines of business. And frankly, if we're going back to structural presumptions and essentially counting heads to decide whether an industry is already too concentrated, I think it's ironic that we're actually limiting the number of heads that can move into any industry. And then let me give two other examples from the report that I think are really good examples of what I talk about with respect to stifling innovation and harming consumers. So with respect to essential facilities, if we mandate that the product of significant investment in R&D on the back end be shared with rivals, I think it's going to lead to a lot of free riding and a lot less investment. I think the Supreme Court was right when it said that Aspen Ski is at the outer bounds of Section 2 law, and I think we should keep it that way. With respect to product design, I was actually quite surprised to see in the report the recommendation that Congress should consider whether making a design change that excludes competitors or otherwise undermines competition should be a violation of Section 2, regardless of whether a design change can be justified as an improvement for consumers. And I think this essentially says, we're going to outlaw product improvements if it causes inconvenience for rivals. But competition is inconvenient, and that's what drives change, beneficial change in the marketplace. I think consumers want to see advances in technology, and if we are outlawing them because it's inconvenient for rivals, consumers are the ones that are going to suffer. And I said 2 points, but I have one more. With respect to predatory pricing, Becca's smiling, she has seen this soapbox speech before. If we remove the recoupment element for predatory pricing, then I think we are going to see less aggressive pricing in the marketplace. Consumers benefit from lower prices, and it's the reason we have a recoupment element in predatory pricing analysis today. We want companies to offer aggressive prices to their customers. And I know that Tim Wu is bemoaning the fact that CVS prices for Claritin are so much higher than Amazon, and he wants Amazon to charge higher prices. I think it's the flip side, actually, of the argument we should be making. Isn't it great that Amazon offers lower prices? Isn't it great that we have commodity flour companies who are making baking flour at $1.99 for 5 pounds instead of $6 for 5 pounds, which is another op-ed that Tim Wu wrote for the New York Times. I don't understand the resistance to lower prices for consumers. And Herb Hovenkamp said, if folks truly understood the implications of what these proposals mean for low prices in the marketplace, there would be a revolt against all of these neo-Brandesian ideas. And I agree.
Well, I actually want to ask.
Stephen?
Yeah, please, with a response.
Can I respond? Great. I was smiling because I have heard Christine talk about some of these things before, but I was also smiling because at the beginning, Christine had said that we don't agree on anything in antitrust. And for the first several minutes of what you were saying, I was totally in agreement with you, which is to say, first, your point about resources is good and well taken. I think that it is true that we can't just keep adding to our workload. We need to be smarter about it. So part of when I say we need to do more, it doesn't just mean bring more cases or do more investigations. I think we need to think carefully about how can we have the most effective reach with the cases that we bring, and how do we prioritize cases? So I take that point well, and I agree that more resources are very much needed, even to do the workload that we have today. And the other point is, you framed it fundamentally as the question is, how do we want to structure our economy, and how do we want to incentivize innovation? And I actually fully agree with that too. I think that is the fundamental question that we're asking here. And I share your view that what we should be incentivizing is innovation and development of new businesses and new ideas and growth. So we have agreement about those things. I think we just have fundamental disagreement about how to achieve them and what the different policies would do in those circumstances. But from a framework perspective, I think that that's right. And then to your last point about lowering consumer prices, I think there's obviously a value, particularly a short-term value to consumers to having the opportunity to pay less. But I think some of the questions that we're asking, and this goes back to the point about economic structure, is what are the long-term structural implications for our economy and for access to different types of businesses and different types of ideas? And cost is not, I mean, even under current law and jurisprudence, cost isn't the only thing that the antitrust laws recognize as important. We want to make sure that we are creating opportunity for innovation, that there's competition on quality, and that there's more availability. So I think thinking about how some of the short-term and long-term incentives can be in tension with each other is an important and difficult question that we need to encounter.
Well, I want to ask a question on resources, since that's a topic that's been brought up quite a bit. And Josh and Edith, I want to come to you on this, because in the House Judiciary Report, there was some recommendations around resources, including greater funding for the FTC, more resources to use its authority to study markets under Section 6B, as well as the ability to impose civil fines on companies for engaging in unfair methods of competition. Josh, what do you think of those proposals? And looking back on your time at the FTC, could you have done more had Congress given you more resources?
So I will say my overarching response to the report was that it was difficult to find anything where I had a hard time finding anything I could support other than the recommendation for greater funding at the agency. I testified and sent testimony into the House in writing, and that was the sort of only overlapping recommendation. So I certainly think that I could support that particular recommendation. I think any agency can do more with more funding, but there are areas where I think that are high rate of return areas for the agency. They aren't necessarily the sexy areas that get you, panel conversations and big tech lawsuits, but I think there's plenty the agency could do with more funding and more personnel. And so I think that recommendation is just fine. Outside of that, I had a difficult time finding anything to agree with. And I think the comment I started on was to say, I take Becca's point that there is consensus on the left to do more here, and there's a fight over what kind of more, but there's no doubt consensus, some shared consensus that doing more is better, and we sort of have a discussion over what constitutes the more. But I think if you look at the House recommendations on overturning cases, this is a place where I think you can poke at a little bit and find where the divide is. I mean, there are proposals to overturn essentially every single Supreme Court case since 1977. And I think they're, with the exception of one, many of those are unanimous decisions in which it is a sort of RBG joining Scalia. These aren't controversial points of antitrust law. The Brook Group requirement to require recoupment in those cases is not particularly controversial. There's not, any economic evidence anywhere that the recoupment prong is resulting in less competition or ruinous price guide. There's not a story to be told there about harm. It makes life harder for plaintiffs because plaintiffs have to bear a burden of proof in those cases. But in my view, overturning broad swaths of antitrust law. I think there are camps on the left, right, and center that look at some of those proposals and say, goodness, I don't know what the evidentiary basis is to overturn Brook Group or Trinco, or, there's a proposal in footnote 2000 and something to overturn a law review article. Frank Easterbrook's 1984 law. I'm jealous. I wish I had written a law review article somebody wanted to overturn. So it's just you're seeing the jealousy come out. But it is ambitious and it touches everything, and that's what these reports do. So I don't mean to sort of harp on one proposal or another specifically, but people take this proposal seriously, and I think there are some that very much demand discussion. I think there's a great conversation to be had about potential and nascent competition. I think there's a great conversation to be had about agency funding. I think there's a real conversation to be had about what sort of fining and sanction authority the FTC should have, both on consumer protection and competition issues. There are some really hard questions that I think merit study. I think that the House calls attention to, and that is an excellent thing. And where they provide data and evidence. And I think there's a bunch where they don't. And I think that's sort of where the dividing line is, I think, for different possible sets of priorities that will come out of that thing. I'm not, I think Becca referred to, I think I've already expressed my skepticism that much of this becomes legislation. Most of that's generic skepticism about Congress passing legislation rather than anything specific about antitrust. But I do think in terms of agency funding, I would think a lot differently about supporting agency funding if some of these ideas were on the table. Because I sort of like Christine said, I think some of these priorities are more worthy of the commission's time than others.
Well, Edith, could you weigh in here on the funding question and the court question?
Let me weigh in certainly on the funding question and say the following, Stephen. To me, more funding to me is vital. And let me give you a couple of examples. And when I became chairwoman, one of the things I actually wanted to do was to really engage in a merger retrospective study. And I assembled the team, and I had ideas for other studies and other recommendations about studies. But the reality is that these are incredibly challenging to do, and they're incredibly resource intensive. In my view, especially when we're dealing with such challenging questions that face us regarding the digital economy, the FTC is so well positioned to be engaging an in-depth study that can allow us to better understand things like the role of data, for one example, particularly given the dual role that the commission plays and the role that it has with regard to privacy and data security. But to be able to do that, you do need a lot more funding. So even apart from questions about what does this mean in terms of enforcement, there's a lot that the agency can be doing. And to me, that's oftentimes where the agency is not able to do everything that it would like to do. So I think it's vital, and it's particularly vital when we're dealing with challenging questions and where there does seem to be something of in my view, a divide in approach as to how one ought to tackle these issues that are being raised by the House report and by others. So that's just a couple of examples to cite.
Well, I'd like
Stephen, can I give you?
Please.
Can I just give you one statistic on the funding to make more concrete what we're talking about? Because I agree with Josh that data is very valuable. Since 2010, there's been about an 80% increase in merger filings. But as Christine noted, our budget has been effectively flat, which means that we are having to review almost twice as many mergers without any additional resources. I mean, and that's really shocking in terms of what it allows us to, how thorough our investigations can be, what kinds of cases we can pursue, and how we can allocate those resources.
I'll just ask a quick follow-up question of you, Commissioner, which is there's a chance in this election that we see Democrats take control of the Senate and obviously maintain control of the House. Do you see a Democratic Congress being more sympathetic to funding needs at the FTC?
I actually think that, as Josh said, that has been an area of bipartisan agreement that, generally Democrats are more sympathetic to funding questions, but on this particular issue, we've heard across the board, and even in the Republican responses to the House report, that everybody understands that funding is an issue. And one of the reasons I talk about the statistics, the actual funding statistics all the time, is because I think all agencies want more money, right? Everybody wants to be able to do more and do their mission better. But I think in the case of the FTC, when the volume of responsibility that is incoming to us is not within our control, but the resources we have with which to deal with that volume has stayed flat or even decreased in some cases in real terms, in terms of, for example, the number of employees we have compared to where we were about 40 years ago. That's something that people understand. And it's true, Christine is right. We get letters from Congress all the time asking us to open investigations or prioritize this issue or prioritize that issue or write reports. We get a lot of directions to write reports. And I think there is bipartisan agreement that burden on us needs to be paid for somehow. But that tends to be the beginning and end of where bipartisan agreement on government funding goes these days.
Well, I'd like to move shortly to audience questions, but I want to get in a few more of my own before we do that. I want to talk about Section 13B. In the past year, 2 appeals courts have now ruled that the FTC doesn't have authority to seek monetary remedies like disgorgement or restitution. And the Supreme Court has agreed to hear a case on this. For Commissioner Wilson and Slaughter, how have the appeals court's decisions impacted the FTC, practically speaking?
So for those folks who are not playing inside baseball, let me just explain what we mean when we talk about 13B. There are 2 issues that are at stake. First is the ability of the FTC to challenge illegal conduct in court when that conduct has ceased. So, for example, if there is a fraudster who is running, a scam, and we open an investigation and the fraudster immediately ceases his conduct, under certain opinions that have now been issued in district courts and courts of appeals, we are unable to bring suit against that fraudulent conduct that's resulting in essentially the theft of money of American consumers because the fraudster has halted his conduct. And the second is the kind of monetary relief that we can get under the 13B statute. And both of these issues are at play, and both of them have a very real impact in terms of recovering money for consumers who have been subjected to fraud and theft, and halting conduct that we have every reason to believe will resume immediately after we close our investigation. And so I have testified before Congress requesting a legislative fix. As you mentioned, we do have, we petitioned for cert, and we'll be making our arguments to the Supreme Court later this term. I do hope that we are successful. Frankly, I think this is a more important issue on the consumer protection side than on the antitrust side, just because of the vast number of cases that we see with respect to frauds and scams. Because especially now, as we face COVID-19, we are seeing a scaling up, as we always do in emergencies, of illegal activity trying to sell consumers products that will, quote, cure COVID when they won't, and that sort of thing. I think it's a really important issue. We are talking with Congress about getting a legislative fix. We will continue to pursue this issue in the courts, and I do hope for a positive resolution so that we can continue our enforcement mission.
Commissioner Slaughter, do you see this having an impact on the work the FTC is doing right now? And do you also agree there's a need for some sort of legislative solution here?
Yeah, I actually agree with everything Christine just said. As much as we disagree on some of the antitrust stuff, I agree with all the things that she just said about 13B. And I think the thing that's important to understand is that these recent court decisions represent a departure from the widespread understanding of what the law allowed us to do for 40 years. And the things that the law has allowed us to do, including, as she said, stopping bad conduct, and what I think is one of the most valuable things we do, returning money to defrauded and wronged consumers. I would, in every single circumstance, prefer to put money back in the hands of consumers than take it and put it into the US Treasury. I think that that is one of the best things that we can do. And our ability to do it being imperiled not only creates this cloud of uncertainty, it is having real world consequences on the cases we bring right now, because every defendant, I mean, I don't think it's an exaggeration to say, and I don't think Christine would think it is either, to say that basically every defendant we meet with waves these decisions around and says, and uses them as an argument to either not settle with us at all, refuse to pay money back to consumers if they're willing to enter into a settlement, threaten extensive litigation, and try to leverage it. So the uncertainty is hurting consumers right now. I hope that we'll prevail in the Supreme Court, but what I really hope is that we don't have to wait for that outcome for Congress to fix it, because I know that our overseers in the legislative branch care a lot about our ability to directly help their constituents. They ask us to do it all the time. And so I know that they share the concern that we have about making sure that we can make consumers whole when they have been wronged.
Well, I want to talk next about the independence of the FTC, both in this current administration and looking ahead to the next administration. In May, President Donald Trump signed an executive order on social media and suggested that the FTC consider action against companies that, quote, restrict speech in ways that do not align with those entities' public representations. That executive order has raised some questions about the FTC's independence. In your view, what should the FTC's relationship with the White House and an administration look like, and how responsive should the FTC be to the administration? Perhaps we'll start with Commissioner Wilson on that question.
Sure. So first, let me say I agree with essentially everything that Becca said about 13B, and we do agree on a fair amount. And and you can see, I think, the kinds of conversations that we have behind the scenes, even when we disagree. We love to engage on these issues with each other. I do think that we agree on the end goal, which is to make sure that consumers in the United States are as well off as they can be. And sometimes we disagree on how to reach that goal, but I would say that's a consensus actually among every member of the commission, and we do have really good, vibrant, robust discussions with each other about those issues and how best to achieve the goal. With respect to the FTC and the broader constellation of the federal government, obviously the FTC is an independent agency, and we have a 5-member commission that benefits from having 2 different parties represented. It gives us steadiness in enforcement so that you don't have the wild swings depending on who is in the White House. But I would say in practice, there is little contact between the White House and the FTC, but there is often close contact between the FTC and other parts of the administration, and that contact is beneficial. So for example, we interact with HHS on ways to inject more competition into the healthcare space. We interact with the FDA on how to ensure that there is sufficient competition for generic drugs and for biologics. And obviously the Department of Justice is still the FTC's lawyer on many things. In fact, I think consumers would benefit if the FTC had a seat at the table even more frequently when the White House is coordinating policy across the government. I think the FTC is a strong advocate for competition at the federal level, of course, also at the state and local levels, and brings a great deal of expertise to the table, both in terms of competition and consumer protection. And one of the reasons that we bring this expertise is because of others on the panel have pointed out, we have a history of studying and doing hearings and roundtables and workshops and conducting 6Bs and taking in information from stakeholders. And I think the merger retrospective program is fantastic and should be expanded. We're doing a number of 6Bs now on competition in various industries. I wish we could do more. I wish we had the resources to do more. And so I think the FTC brings a great deal of expertise in a variety of areas that could benefit the broader society if that were if that were more integrated into the work of the federal government. And I'll give you another example. You know, there has been a fair amount of clutching at pearls over the executive order that President Trump issued recently, but something very similar occurred after the Columbine school shooting in late 1990s. So the Clinton White House in June 1999 asked the FTC to study media violence. This was the Clinton White House asking the FTC to conduct a study. Members of Congress made similar requests. And in September 2000, the FTC issued a report that was hundreds of pages long, finding that, in fact, movies, music, and video game companies did routinely target children with violent entertainment. And in response to those findings, the commission made recommendations regarding self-regulatory steps the entertainment industry could take, and those steps were enacted. So, and then let me just talk for a moment about the specific executive order that President Trump issued. This is, in some ways, a very bipartisan agreement. I know that Commissioner Slaughter and Commissioner Chopra share my concerns about the ecosystem that incorporates, you know, the interactions between content curation and targeted advertising and data collection and monetization and the creation and refinement of algorithms. In fact, Congressman Nadler raised these questions when Google's CEO was sitting before him. He asked, you know, does the ability to make money in any way affect Google's algorithm in terms of what news appears in a typical user's search results? He expressed significant concern about that. And so when we have tech companies that filter the news that you're shown, what ads you get, and what posts you see, but provide no transparency how they make those decisions, I think that is an issue that is worthy of study. And that is an issue that both Commissioner Chopra and I have issued statements about jointly, and that Becca has also said publicly, both with me on panels and elsewhere. It's an issue that we should be studying.
Well, Edith, I'd like to come to you. You led the FTC under President Obama, obviously. Do you see an independence question here? You know, this executive order from President Trump came down shortly after he was penalized by Twitter for violating their policies, and many have seen this as a response to that, you know, that action. What's your take on this independence question?
Yes, Stephen, I guess what I'll say is that it's absolutely essential that the FTC, right, the law enforcement function, be thoroughly independent, and I believe it is. Certainly during my tenure, there was never any effort and very little interaction with the administration. That's different from policy matters, whereas Christine has noted that it's important for the agency to weigh in on certain policy matters that do implicate competition, and to be also at the table along with the Department of Justice's Antitrust Division. But in my view, it's crucial that the agency, as an independent agency, be completely autonomous when it comes to its law enforcement function. And I think, in my experience, that's exactly how the agency has acted.
Well, I do want to move on in our last 15 minutes to some audience questions, because we've gotten a number of good ones. I'll sort of use moderator's privilege to direct the question to a specific panelist, but certainly if you all, you know, want to weigh in or have a counterpoint, please feel free. Perhaps I'll first come to Commissioner Slaughter, and you can also introduce us to our new panelist who I see has joined us. But the question is, would a Biden administration FTC or DOJ be likely to move away from the consumer welfare standard?
Thanks. Yes, this is Hattie. My loudest coworker woke up. I almost timed this well. I'm still working on it. But she has a lot of thoughts about the consumer welfare standard and antitrust that she will probably express in the form of dinosaur-style shrieks, which is her current mode of operation. So again, look, I can't tell you anything about what the Biden administration will do. I can tell you about what I think as a commissioner who has no plans to leave her job anytime soon, which is, I think there's a lot of Sturm and Drang about the consumer welfare standard, and a lot of times, not unlike, frankly, with Section 230, it involves people sort of talking past each other because it can mean different things to different people, and its legal application is understood differently by different people. What I would say is I think it is important in our cases for us to be contemplating the entire universe of harm that a potential transaction could, or conduct could impose, including quality, innovation, and cost and price. I also want us paying a lot of attention to monopsony style harms on the worker side or on the supply side. So I think that is something that is absolutely contemplated by current law, and I think, in fact, is frequently contemplated in many of the cases that we discuss and bring. So I don't know if you call that moving away from consumer welfare. I think different people would and other people wouldn't, but that's how I think we should be thinking about cases, making sure we understand the entire economic structural ecosystem into which the particular question that we're dealing with, whether it's a merger or conduct question, falls.
Well, this next question, I'll point to Josh on this one. It's from the audience. State attorneys general have been very active in these tech investigations. We see that today with the DOJ suit, where they're joined by some Republican state AGs. How would proposals for FTC rulemaking authority or increased federal funding impact the work of state AGs?
That's a great question. I don't think that the sort of immediate implication is clear. I mean, to the extent that we mean the expanded role for competition rulemaking, and I do think, for what it's worth, I do think that is where some of the current trends are heading. I think expressed in different forms, skepticism that much in the House report will be done through Congress. But to the extent that one wanted to make changes, it takes 3 commissioner votes to do a competition rulemaking. And I think there's, in a Biden administration, it is likely that some of that is there's a more administrative law in the future of antitrust lawyers than they are currently accustomed to. Because I think that's going to be some of where these policy debates play out. What that means for state AGs, I don't think much. I think you're seeing a rise in state AG enforcement by both Dem and Republican state AGs for different reasons. It's politically salient on each side for different but related reasons. And so you're going to see this sort of separating equilibrium where everybody's involved but never together, because they can't be seen in the same room together or whatever it is. But you're going to see a lot of state AG enforcement, more on the national sort of federal side scale than I think we're accustomed to. But I don't think if you have more rulemaking at the FTC, or even if the FTC gets busier, I don't think the trend of seeing more state enforcement is going away either way. I think it's to some extent a secular trend.
Edith, we'll come to you on the next question, also from our audience. Counterfactual analysis is challenging, especially in cases of nascent competition. How do antitrust enforcers evaluate their own performance?
Stephen, I think we touched on this earlier. I mean, I think that, as I said, cases involving nascent competition can be particularly challenging. In cases just generally involving potential competition, future competition can be challenging, both in terms of agencies endeavoring to get the right answer, to do the right thing in a particular case, but then also having to be mindful of how a court may, if you bring an action, how a court may ultimately decide a matter. I don't believe, as I noted earlier, that there's any systematic problem with the way that agencies have been approaching merger enforcement. But at the same time, I will not say that we always got it right. I think certainly in my experience, you do the best that you can with the information that you have available at the time. And that's the best that you can do. You can endeavor to get the right answer. I think in order to assess whether or not the agency is performing as it should, you do exactly what the FTC is doing in this arena, which is to conduct a 6B study. And that's, I think, what an agency needs to be doing on a regular and ongoing basis. And I think that does happen even when it's not a formal study that's publicly announced and where the findings are publicly announced. I think that's something that the agency does undertake. And frankly, I wish there were additional resources, I've noted earlier, to be able to do that on a more regular basis. But I think the FTC is doing exactly what it needs to in this area.
And then, Christine, I'll bring this one, or Commissioner Wilson, I'll bring this one to you. It says, how is the state of economic analysis at the FTC? There are many questions regarding tech companies that are theoretical rather than legal. Should Congress add resources to the Bureau of Economics?
Great question. I highly value our colleagues in the Bureau of Economics. I worked very closely with economists when I was in the private sector, and I think that the view that our economist colleagues bring to the table is incredibly important. I have an economist from the Bureau of Economics who works with my office on essentially every antitrust matter, Jeremy Sanford, and he is absolutely stellar. And we have lots of other folks like him in the Bureau of Economics. Could we use more of those? Absolutely. But again, we also have the benefit of conducting workshops and roundtables and hearings and putting out for comment, for example, the draft vertical merger guidelines, where we get to have the input of incredibly bright folks like Josh and other heads of the economic divisions of the FTC and DOJ and other economists who are in academia, as well as practitioners. I think we have a lot of knowledge and skill at our fingertips, and sometimes it's not formally within the Federal Trade Commission. We have to look further afield to obtain that input. But we do have a lot of that. That's not to say that we can't do a better job. We can always think harder. We can learn more, and sometimes it would be helpful to have more in-house resources as we think through some of these issues regarding potential competition, nascent competition, trying to figure out how to make the right call in a merger where we know that the industry is dynamic and technology is evolving, and looking into the crystal ball is an incredibly hard thing to do. I've actually called for academics and economists to give us thoughts about how we can see around corners more clearly, but absolutely the role of the FTC economist and the role that economists at large play in input into our thinking is absolutely priceless.
Josh, you're an economist. Do you want to weigh in on this question?
Sure. I mean, an economist who started his career as an intern in the Bureau of Economics doing a 6B study on divestiture remedies. Look, I think it is sometimes the ratio of lawyers to economists in the building is pretty darn high. There are the team of economists that's inside the Bureau of Economics. There's 50 some odd PhD economists, and it is one of the best groups of economists in a government agency anywhere in the world. So the FTC and the Fed, essentially. And I think one thing for people to keep in mind as we talk about all of these proposals for things for the FTC to do, we get a team, the DOJ announces a big Google investigation, or there's a merger investigation, or Becca noted the uptick in mergers, and we want to review them. And we're going to have a team of 6, 7, 8, sometimes 12 lawyers doing part of investigation. And there's going to be one economist. There's going to be one economist on each of those, maybe 2. You can find a handful of big investigations where there are 2 staff economists, and they write a memo. the lawyers get a team of 12 people and they write a memo and it goes up to the commissioner's offices, and those guys are doing a ton of work. And then we're going to ask them to do studies and 6Bs, and somebody who's done a merger retrospective this is really hard stuff to do that takes a lot of work. And so I think sometimes we think about agency output in terms of the number of cases they're bringing in, or winning or losing, or something like that. But I think a really important decision for the FTC on prioritizing its direction is if it wants to be a player in figuring out these questions, and having the benefit of economic analysis in its cases, both on the consumer protection side and the competition side. There's just no way you can do that with the number of economists that they've got right now. There's other in-house resources that could be helpful too. I guess you can always have more lawyers, or technologists, or something like that. But let me make a small plea for my economist friends, that I think that is one of the most resource constrained units in the House, and I think is really critical. While we talk about expanding sort of our activity level over a bunch of hard questions, is to free up some economist time to be doing the research, or to be doing on the case, to work on the cases, or maybe enough that we don't have just one economist on a case.
Well, I think that about puts us at time. I want to thank Commissioner Wilson, Commissioner Slaughter, and of course, former Commissioners Ramirez and Wright for joining us today for this conversation. I think we'll all be watching to see what the next administration, whether that's a continuation of President Trump or President Biden, how they handle these antitrust issues. But again, thank you all for being here today.